Hi. So this video is about Indian Contract Act. I have tried to keep it as short as possible and cover as much as possible. It obviously doesn't cover all aspects of it, but hopefully it will give you a good introduction. A contract is any transaction where you promise to do something for someone and the other person promises to do something for you in return. That's not a legal definition, but that's a good idea for understanding. There are three components to a contract: a, a competent party, reasonable and valuable consideration, and free consent. All these three create a contract. Under common law, there's also another requirement, which is the requirement of a legal intention to enter into a contract. Let's quickly discuss examples so it becomes clearer. For instance, you go to buy a pencil from a shopkeeper. That is a contract. You pay him the pencil, you pay him money for the pencil. Now you promise to give him money and he promises to give you a pencil. Now that constitutes a contract. So assuming that you are a competent party, for him the consideration is the money. For you the consideration is the pencil. A free consent, the concept we'll explore later, but basically means you're both willingly entering into that transaction. Now, other examples of contract I have noted down below, you can go through it, but it typically includes most transactions that you enter into or pursue in your life. Now, the Indian Contract Act is roughly divided into five sections, and the first section is just a definition. I have dealt briefly with validity of contracts, with performance, damages. While I have not delved into special contracts, I have mentioned what different kinds of contracts have been given special treatment under Contract Act, which we'll quickly see. Now, let's look at the basic concepts. The first is free consent. Now, consent would mean consent, the requirement of a consent is first you should have a capacity to consent. Minors are typically not considered to have capacity to consent, and neither are people of unsound mind. So, any contract entered with them is not valid. The second aspect of free consent is that the consent should be free. So, even if it's a person who is capable of entering into a contract, first of all, he should be entering into the contract without any fraud or misrepresentation. For instance, if you go to buy milk and the shopkeeper tells you, yeah, he has fresh milk, but the milk is actually expired. So now that was fraud. So that is not a valid consent. Second is undue influence. Now, undue influence refers to where a person close to you uses his position to with or his closeness with you to make you enter into a contract which might not be to your benefit. So that kind of contract is also invalid. Now, coercion is use of force or threat of use of force. Then we come to public policy. Now, certain contracts, even if they're valid, may not be enforceable. For instance, gambling contracts. Now, contracts, oh, an interesting example would be lottery contracts. So, even if you win a lottery prize, the company the company refuses to pay you, you cannot go to court and enforce that because gambling contracts are against public policy. So while it may be a valid contract because it satisfies these three conditions that have been noted here, however, because it's against public policy, you cannot approach the court to get your prize. The other two contracts are unconscionable and immoral. Basically, any contract which shocks the moral conscience of the court is considered against public policy. Now, this is relatively broad definitions which you will read in details in your contract law class. The third aspect of contract is performance. Now, what do you mean by reciprocal promises? Reciprocal promises means promises made in return for another promise. For instance, let's take that pencil example again. So you promise to pay the shopkeeper money and he promises to give you the pencil. Now, these two constitute reciprocal promises. The second aspect is breach. Breach means that the contract has not been performed in the manner it it was documented or expected to be performed. Now, the breaches can be of two types. One is material or repudiatory breach, and the second is non-material breach. For instance, let's take, for example, your employment contract. Now, your employment contract says you have to come to office at 10 a.m. every day. Now, assume you come to office at 10:05. Now, it is a breach because you failed to live up to the terms of your contract. But is it a material breach? Probably not. So that means that the contract, your employer can probably claim damages if he has suffered loss because of you not turning up for those 5 minutes. But he cannot end the contract or fire you. Well, unless it's written specifically within the contract, it's expressly documented. However, that is another aspect which I'll cover in another video. Material breaches, on the other hand, means that your breach is so vast or so important that the other party will have the option to terminate the contract. So, what do you mean by terminate the contract? For instance, in breach of your employment agreement, you don't turn up for work for a month. Now, that would probably constitute a material breach. So, that would give the employer a right to end the contract. Basically, in other words, fire you and also claim damages for losses that he has suffered because you did not come to the office. Now, there are two kinds of damages. One is liquidated damages, the other is unliquidated damages. Now, liquidated damages means when there's an amount mentioned in the contract. For instance, we often see that airline tickets mention an amount saying 3,000 rupees will be deducted if you cancel that ticket. So that's technically a liquidated damage. Now, unliquidated damages means when no amount is mentioned, but that does not mean you can't claim damage. It just means that no amount is mentioned, so you have to approach the court to determine the amount. In fact, in under Indian law, even in case of liquidated damages, technically the court is supposed to determine the amount. This is an interesting concept which you'll hopefully learn in your contract law class. Now, lastly, we'll talk about the three special contracts. So the three special contracts can be broadly categorized into indemnity slash guarantee, bailment, and agency. Now, what do you mean by indemnity contract? Indemnity contract means that one person takes the responsibility to refund the other person for all the risk that the person is taking. For instance, a good example of an indemnity clause might be insurance. That the insurance company takes the responsibility to refund to me all my medical costs in case I fall sick. So that technically becomes an indemnity clause. Now then you see guarantee clause. Guarantee clause, great example is a bank guarantee where a bank A gives a loan to company B and say the promoter of the company or the owner of the company gives a guarantee saying, okay, you can recover money from me also. The second type of special contract is bailment. Now, bailment basically refers to possession of the goods. Uh, possession, now the possession can also include the right of sale, and if it includes the right of sale, then it becomes a pledge. For instance, you must have heard that promoters have pledged their shares for a loan for the company. So that basically means that the promoters have given their shares to the bank as security, and now the banks can sell that shares to recover the money. Now, on the other hand, lien, you might not have heard of it, but it basically means that you have possession but not sale. For instance, if you give your watch for a repair, so until you pay that guy the money for the repairs, he can technically keep your watch with him. So that is a possessory interest. So that means he has possession of your watch until you pay him that money. So he has a lien over the watch. The third example is agency. Agency means there's a principal and there's an agent. Now, the agent can enter into contracts on behalf of the principal. For instance, an LIC agent. When you buy an insurance from the LIC agent, you don't enter into an insurance contract with him, but with LIC itself. Now, that is considered an agency contract. Now, say the LIC breaches their contract or the agent fraudulently sells you the contract. So then the relationship between the principal and the agent becomes an important concern, which is why it's considered a special contract. So with this, we come to the end of the video, and I have tried to keep it as brief as possible. Hopefully, this should be a good introduction. Thank you.